Now to our legal landscape. Our legal analyst, attorney Dan Adams, joins us every Monday breaking down the biggest cases happening across Wisconsin and the country. Good morning to you, Dan. First up, an Ozaukee County conservative activist actually won her appeal in a defamation case after being sued over posts criticizing her school district's so-called woke agenda. Tell us more about this case and what happens next.
Sure. Good morning, Mallory. So there was a circuit court case for defamation. There was a teacher in the Mequon-Thanesville school district who had an aged LinkedIn profile that showed she was the social justice coordinator for that district. This conservative activist came in and screenshotted it, made some comments about these type of activists being, woke, having God complexes, white savior type things. And really made this plaintiff, this former teacher, pretty upset with these statements that she made online, kind of broadcasting about this former teacher's professional reputation. She sued her for defamation, saying that these things were not true and that she was damaged because of the statements. She went to circuit court. They had a big hearing about it. And the judge kind of in circuit court gave a mixed opinion about what could be shown to a jury and what was not. The Court of Appeals, Judge Joe Donald, took a look at these statements and reversed and basically said none of these things are statements of facts, things that could be objectively decided whether it's true or untrue about this former teacher. These are all kind of mixed opinion statements, whether somebody's a bully or woke or that type of thing. These are not things that are demonstrably true or not, so they can't be defamation. So the case is being sent back to circuit court to essentially be dismissed. Now, the plaintiff, the former teacher, could ask the Supreme Court of Wisconsin to take another look, but that court doesn't take a lot of cases. So again, this is probably the end of the road for this defamation case.
All right, and this week, the U.S. Supreme Court will hear oral arguments in a pair of challenges to President Donald Trump's power to impose large tariffs on goods imported into the United States. What are these challenges based on, and do you have an idea as to how the court could rule?
Right, so they'll hear this on Wednesday. Back in April, President Trump used emergency powers under kind of an obscure statute to impose incredible tariffs, the biggest tariffs that have been imposed on foreign trade partners of the United States in 100 years. Traditionally, tariffs are a tax on goods coming into the country. So traditionally, the Congress is the one that imposes the schedules for tariffs. The president said, listen, we have this trade deficit that's out of control, so this constitutes an unusual and extraordinary circumstance. That's the term of art here, unusual and extraordinary, that allows me to use emergency powers to get involved in these trade deals. The plaintiffs are small businesses, a collection of other businesses who are importers of goods who've been damaged by these tariffs. And they say, no, listen, there is no unusual and extraordinary situation. These trade deficits have been going on since the 1970s. Your explanation of an emergency is terribly broad, and only Congress has the power to impose tariffs. And so three lower courts have agreed with those plaintiffs and said, no, the president has overstepped his powers here. And so the Supreme Court's going to be hearing whether or not those courts were correct. But of course, the Supreme Court these days is very deferential to the presidential power, especially in terms of emergency and foreign affairs type issues. So it's a very contentious issue. I think that they're going to come back with a decision sometime later this fall or early in the winter.
Yeah, definitely a topic a lot of people are looking for answers on. Dan, thank you so much. We'll see you again next Monday for more of the legal landscape.